religion to absorb religious philosophy and truths. Now, my lord, if we appreciate that each religion, and my lord, this is applicable to all religions, that they have a philosophy, they have tenets, and they have practice to achieve and to implement and arrive at those tenets. And my lord, the extent is also left to an individual depending upon the tenets of that faith. So, my lord, under Article 25(1), these words, my lord, need to be given a very wide and expansive meaning, because there is an exercise of individual autonomy, even in matters of choice of religion and extent of practice of religion. Note, two people, my lord, may practice the faith the same way, although they may belong to the same religion. But both individuals have complete freedom to practice the faith, practice the religion as they see fit. That autonomy, my lord, is also protected under 25. That, my lord, is different from freedom of conscience. So the freedom of religion, my lord, carries with it not only the right to affirmatively and actively engage in religion, but also establish boundaries within oneself about the extent to which the person would be willing to go and exercise his right. My lord, to this extent, in the area of individuality, it deals with the inner dignity of the person and is therefore, my lord, a very precious freedom which should be given the widest possible meaning. Now, my lord, we come to practice and propagate religion. Here, as a part of faith, as a part of religion, a person may visit an institutional setting. He may have access to an institutional setting. That institutional setting, my lord, is actually 26 of the Constitution. So the denomination, my lord, is where collectively you come together and you express your worship, your faith. All this, my lord, is within the freedom of 26. So in 26, an important point Justice Sundaresh asked, what do the members of a religious denomination do when they arrive at an institution? They exercise, my lord, the rights under 25(1), but collectively, they have the freedoms under 26. So the freedom under 26 is also not entirely, my lord, divorced, if I may say so, from the rights which are actually exercised by members of denomination, because inside the institution, they exercise 25(1) rights. But when they are in 26, and this is, my lord, to deal with a very important question raised by my Lord Justice Bagchi. Suppose there is a proponent and there is an opponent, even inside a denomination. My lord, a denomination also has the freedom under 26 to have internal discussions and debates. That is also a freedom of the denomination. It is not that, my lord, denomination means simply positions of conclusive nature taken by members of a denomination. There can be discussions, there can be debates, and there can be consensus in denominations too. That is also inherent, my lord, in 26. That does not have to be located, my lord, in 19(1)(a). It can be located in 26. So, my lord, although there is an institutional setting, but as observed by Chief Justice Mukherjee, that all corporations and institutions function through individuals. So when you are in a denomination, it is open to you to express your views within the discipline and decency of that denomination. That also, my lord, is a freedom which should be ceded under 26. So, my lord, the freedom to navigate in matters of religion is a matter of personal freedom under 25(1). But when you adopt a creed, when you adopt a philosophy, and if you are an adherent to a particular philosophy, then, my lord, you come under 26(b). Then you cannot actually attempt to change the doctrine of that philosophy while entering as a member of a denomination. That is not expected because you're an adherent of the denomination. That is why under 25(2)b, the expression, my lord, all classes and sections of Hindus not only refers to excluded classes or members of castes, but also includes denominations. That is, access to the temple should be open to people of all denominations. So, my lord, if you read it that way, you will find that there is an organic movement between 25(1), 25(2)b, and 26. So, my lord, 26 cannot actually have what is called a sui generis existence without walking through the gate of 25 and an intention to, my lord, form an organization in aid of practice and propagation. Now, my lord, yesterday I mentioned that the word denomination is not necessarily a subsect. I said the entire faith is comprehended. But, my lord, when I say that, even subsects are comprehended. When I say the whole faith is in a denomination, then, my lord, even those who are sections are also, my lord, identifiable under 26(b). So, my lord, cases like Shiru Math, cases like the Shivachar, all these cases will, my lord, come under sections. And they would also get the same ability to assert rights under Article 26. My lord, what is significant in the debates is it is clear that the framers were aware of the administration of endowments. They refer to it, my lord. It is also clear that they wanted Article 25 to be an article of a universe, giving absolute maximum freedom, subject, my lord, to public order, morality, and the rights of others. My lord, no individual right can be exercised in violation of the rights of others, because all have identical freedoms. At the same time, in order to see that the right of practice and propagation, my lord, how do you propagate? For that, you need a denomination. And that denomination must have the ability to acquire a whole property. And it must also be able to establish and maintain an institution. My lord, Article 26 is not simply about management, my lord. The concept of management, maintaining and establishing an institution, and also, my lord, regulating affairs in matters of religion can touch upon religious matters under 26(b). And I'm urging your lordships to take a view that nothing, my lord, is non-justiciable. The only area of non-justiciability is, my lord, a devotee's faith in a certain philosophy or towards a certain deity. That, my lord, is something which is completely different, my lord, from a secular scrutiny of infringement of these rights. So if we stay within, my lord, the constitutional boundaries of 25 and 26, I submit, my lord, that your lordships are not precluded in any way by any manner to inquire and determine what is the religion, what are its basic tenets, and how is this religious faith being asserted. So, my lord, I submit all these cases, my lord, judges have been able to acquire a certain knowledge about the fundamental tenets of faith. And when I say faith here, my lord, I mean religion. Because the faith of the worshipper, which is a private matter between him and his maker, is not the area where the court interferes. And that is why, my lord, I want to say that is an area which is so totally personal to a worshipper that that is not the area where judges interfere. But up to that point, the fact that he has access to a religious freedom in a temple or in any other form, my lord, a church or a mosque, somebody who professes that faith, is an underlying theme, because that is how you will make religious freedom through community feeling possible under 26.
Mr. Subramaniam,
Yes.
as you rightly said, that 26, as there is also a scope for deliberation, discussion, a healthy exchange of view between those following that denomination, and that's very nicely expressed in the Vade Vade Jayate Tattvabodha. This is the scope, so where we can certainly put our what you can say, the views, have a discussion. So that scope is there.
Certainly. And that, my lord, has to be located in 26. Because we are not looking at, my lord, shall we say, inert denominations. We are looking at people who would have views. And, my lord, this is a process of interaction. My lord, when we are looking for even a transcendental interaction, in that process, you're likely to have human interactions. And sometimes they can be collective worship, as Justice Sundaresh said. They could be people who are going together to offer worship.
So, Mr. Subramaniam, since you are positing the intra-debate in a denomination in 26B instead of, let us say, 25.1 or 19.1A as I proposed, you would put this in the word manage. Manage will include internal dialectics.
Correct, my lord.
We have to interpret the
Yes,
word manage.
yes, you have to locate it.
Locate the word in manage.
Yes.
Manage affairs means debate over the affairs themselves.
Yes, yes, and it is perfectly, my lord, plausible. It is perfectly consistent. And, my lord, such debates have taken place. The point is, my lord, debates have taken place. We have, my lord, so many schools of philosophy, as your lordships know, in one faith. You have NYAYA. NYAYA contemplates debate in the very nature of things. In one, logic is supreme. In one, experience is supreme. My lord, there are different schools. And that is why, my lord, as I said yesterday, my lord, the limited picture which we are getting from these judgments about certain temples where certain agamas had to be followed does not actually give you a complete picture. Because when we deal with this fundamental right under 25.1 and 26, we must know all these four aspects, they exist. The religious doctrine, then, my lord, the practice of that doctrine, and, my lord, if it needs any external manifestation. I'll give your lordships an example. My lord, in the Hindu tradition, there are worshippers who follow Vedic Shastras and do not follow agamas. They follow only Vedic Shastras. They only use Vedic mantras as their basis. They do not, my lord, go to the agama khanda at all. My lord, that is one pathway. There are others. And, my lord, this evolution of temples was also a very forward-looking way by which people could come together and have fellow feeling as my lord, fellow feeling of connectedness with members of a community. My lord, this is extremely important. Yes.
Intra-religious fraternity.
Yes. And my lord, these are all ways. And my lord, ultimately, the meaning of the word religion, I'll show your lordships some treatises which deal with etymology of religion. My lord, the word religion itself means to bond. The true meaning of the word religion in etymology, my lord, there are two definitions. One is given by Cicero.
Isn't it experience, spiritual experience?
Lord, I'm a little hesitant to use the word spiritual experience because, again, Lord, it is within the inner realm of experience. Inner realm of experience. So, my Lord, if someone were to read a book, my Lord, that's a book called The Eternal Companion by Swami Prabhavananda, which was on the life of the first disciple of Sri Ramakrishna, Rakhal Maharaj. That is, my Lord, a case of pure religious experience. That is a case of spiritual, inner experience. We don't bring this, my Lord, here because it is treated as guaranteed as a part of the journey under 25. So we don't, my Lord, call it out specifically because it varies, my Lord. It is so subjective. It varies from person to person.
So once a secular activity, the boundaries of a secular activity associated with a religious practice is identified, all other things are religious.
My Lord, all other things are religious, but I will tell you, my Lord, where this essential religious practice may be of relevance. I'm trying to say something, my Lord, very cautiously. All your lordship's judgments are not, my Lord, they have not been written, they've been written with reflection. Well, we must assume so. And therefore, the evolution of essential religious practice is in the context of dealing with claims based on religion, which may not belong to religion at all, but are being masked, but are being clothed with as being religious under the mask of religion. Your lordships must have a tool by which you are able to deal with it. That is why in two of the judgments, your lordships employed a test, which is also correct, because, my Lord, you cannot have just one line test. There are multiple factors. You can use the test of an obligatory act. Then it becomes central to religion. I'm giving your lordships an example from decided cases. Chief Justice Das's judgment in Hanif Qureshi's case, where he referred to a certain act not being obligatory. Justice Rohinton Nariman's judgment, where he said that a certain act is not treated as an act commendable, exalted by scripture, and therefore it cannot be treated as something integral. So, my Lord, the words integral and essential need not cause, if I may say so, any kind of turbulence or enturbulation as far as dealing with the questions are concerned. Your lordships have very firm terra firma to deal with this question. And, my Lord, the only point where I see, and I support all my colleagues, is in the matter of the extent of personal faith and experience which a person, an individual worshipper has. Well, that is not the area of inquiry. So when, my Lord, you have judgments which use the words, sometimes you have to find the followers of the faith about the faith. It is a means of inquiry. It is not, my Lord, to pronounce upon the faith. It is only to ascertain information relating to the tenets of that particular belief. If you view it this way, my Lord, it will be clear that there is cohesion in most of the judgments. But there are two important points. One is the only reason why Justice Mukherjee upheld, my Lord, the Hindu Religious and Charitable Endowments Act was based upon a fundamental principle in Hindu law, that the donor's foundation and his benediction and his dedication must be truly honored. That is, all that which comes out of that property must be plowed back So, my lord, it was really an evolution of the doctrine of trust. And, my lord, when they found that the traditional laws dealing with administration of trusts was insufficient, that is, my lord, breach of fiduciary duties by a trustee, and, my lord, section 92, notwithstanding the fact, my lord, it was there in its earlier incarnation in the Code of Civil Procedure, that it was still insufficient to address the need for the deity to whom a dedication has been made, and that a Shabayat must have honestly, in aid of an endowment, became lot principles which sustained this law. But if under the guise of regulation, what was being attempted was actually the management of the temple,
Yes.
then, my lord, it is completely unconstitutional. So, my lord, while the Madras High Court in Shirur Bhatt struck down all the provisions, and, my lord, there's something interesting in the judgment of Justice Mukherjee. He notices a very special section, section 92, my lord, of the 1951 Act, which later became 107, I think, of the 59 Act, which clearly says that no power which will be exercised will interfere with the rights which are granted to denominations under Article 26 of the Constitution. So, my lord, this is the peaceful coexistence. And when he found that it trespassed on 25(1), or it denuded at 25(1) and could not be justified even with reference to 26B, he struck down all those provisions. So, my lord, I submit with the utmost respect that if we give complete respect to the content of these expressions under Article 25 and 26, my lord, I think that there will be absolutely no difficulty. My lord, I just want to show your lordships just a couple of examples.
There is no need to go into this test of essential religious practice.
My lord,
Because an impression has been created that it is only essential religious practice that has to be protected and nothing else.
my lord, this is, if I may say so, if the judgments suggest, and I, my lord, personally do not think they go that far as to suggest, that if it is not an essential religious practice, it degenerates into a non-religious practice or will become a practice which is capable of regulation. I do not think, my lord, any judgment goes this far. But I would submit, if essential religious practice is intended in aid of discovering the true components of that particular religion, then, my lord, it is assistive in character.
Yes.
That is all. And that can be done, my lord, by courts. Please feel, my lord, your lordships can deal with any branch of law to discover something, my lord, which is as sublime as religion is not very difficult at all.
The court cannot sit in judgment as to what is an essential religious practice.
My lord, if I may say,
Our controversy in Sabrimala arises out of that.
my lord, let me
Whether
deal.
the court can discover or distill and sit in judgment.
My lord, this is, let me deal with it this way, my lord.
We will put it this way.
Yes.
The concept of essential practice, as you rightly said, actually, if it exists, it will inure to the benefit of either a religious denomination or a person or a group of persons seeking right under 25(1). Right? So, when it comes to judicial review, 25(2)(b) says on a given on 3 contingencies, it can be exercised over a religious practice. That is why the distinction between 20 and 25, 2A and B. So,
Because of the word religious practice.
religious practice, there's no difficulty. But then, as we're trying to say, as we understand your argument is, you can still go into it to satisfy yourself by the court on the existence of essential practice, primarily from the point of view of the practitioner or the person who is having belief, so as to exercise your power of judicial review, in which case you have to be a little bit more circumspect. Okay, when what is required by the court, and see, the challenge will be only when a law is being created, or if it is not there in the vacuum, that will come only on 2 occasions. 25(1)(a), when is it merely associated any other practice, secular practice associated. To that extent, we can do whether there is no need for essentiality. Because we have to see the religious practice is there or not. If it is there, then it will go away. Then the next one will be 25(2)(b). It deals with the religious practice. There the power can be exercised by the state. In that, the court can go into it, and to caution itself vis-a-vis the existence of a social reform or social welfare. To that extent.
No, let me, I'm very
Yes,
grateful.
Mr. Put it, if it
Yes,
is
yes.
got some touch there, from the point of view of protecting the right given in 25(1).
My lord, I,
Whether it should act as a
Yes.
restriction
Restriction,
or
limitation.
it is only a supporting or an aiding tool for protection.
my lord, may I now read both 25(2)(a) and 26 with you again, my lord, because I think they are very, very, very paramount questions. Please now read with me, my lord, 25(2). Nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. So, my lord, this is a case of a clear boundary between a secular practice and, my lord, a religious practice. They are being juxtaposed, my lord, against each other. This does not cause very much of a challenge, if I may say so. But here, my lord, you may suddenly see that the religious practice which is being invaded is somewhat central to that faith. Can be. Then you don't have to worry about it, my lord, because it is still a religious practice. It is clearly distinguishable. But let us now come, my lord, to B. B is providing for social welfare and reform, all the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. My lord, we will use disjunctive, this clause. Let us look at the first one. Providing for social welfare and reform. In social welfare and reform, my lord, there are two important considerations. Social welfare and reform must not be a cloak. That is, it should not be a colorable legislation which actually seeks to invade religious freedoms under 26(b). Then in that case, my lord, the law is void. If it is a color, if it's a fraud on the constitution, that is one aspect. The second is, your lordships are asking me, suppose there is something called social welfare and reform. Can it touch upon a religious practice? Can it touch upon an essential religious practice? Now, there also, my lord, it is necessary to satisfy the words social welfare and reform. Objectively, there is an element of scrutiny involved by the court to truly examine whether this is advancing social reform or it is eo nomine under social reform.
Gopal Subramanian, in
Yes.
the case of multiple accepted religion or in the case of accepted practices, what is the juridical basis on which the court can interfere?
Well,
Whether the court can declare one is authoritative over the other in case of a dispute arising within the religious practices, accepted practices within the religion.
my lord, I will, can I answer your lordships in two limbs? Because one is the intra-denominational, shall we say, contest about the nature of a practice. My lord, there are cases. You have the most celebrated case, my lord, the Badagalai, Tengalai, that has been going on for centuries. And I still don't know whether it is over. But my lord, I'm giving you an example that there can be contests, but those have to be done.
You take it, it's not over.
Yes. So, my lord, in such cases, you will need, my lord, evidence, you will need proof, you will need to track. But, my lord, your lordships asked me a more fundamental question. That is the court devoid of adjudicatory power? The answer is, my lord, the court is not devoid of adjudicatory power. My lord, there is no other place where any legal rights or legal injury can be established except in a court. I know, my lord, those are not the, not exactly the ideal kinds of situations, but
So the courts will sit in the armchair of ascertaining the theology of the practice?
Malad, there will be evidence. And it can, Malad, may I say again, Malad, please do not.
So can we take it that 226 and 32 will be barred?
Malad, in
It
case
is only
it
under
is
section
an interdenominational fight which requires evidence, then Malad, 226 and 32 may be precluded. But if suppose, Malad, there is no dispute at all, we can have cases where there is absolutely no dispute on the fundamentals. Then in that case, a question may plainly arise for determination whether this is void or not void.
Vis-a-vis the state.
Vis-a-vis the state. But Manoj, I have not yet finished with reference to the social welfare and reform. I need to add more. Social welfare and reform, there is one end of the spectrum, which is it should not be used for hollowing out or, shall we say, eviscerating a religion.
Yes.
That, Manoj, is no social reform. And for that, the onus is too high for anybody to establish as a state. The second, Malord, is this social welfare and reform can touch upon a religious practice if it affects or if reform is required. If reform is required, it can touch upon that practice. Malord, the exclusion of people in temples was justified with reference to anterior texts. Please understand this. This was all justified with reference to some interpretations. But Malord, they've said no. They overrode it. And the reason why they overrode it is, again, Malord, one must never forget that both Mitakshara and Dhayabhaga schools of law are actually to move away from all those rigors. Malord, he was the founder of Mitakshara and Jamuna Vahatata. Yes, that is for Malord Dhayabhaga. Now, both of them, Malord, they were actually progressive thinkers who said we must move away from so-called edicts, which are written in Smritis and some of them, because they said for the purpose of dealing with present reality, for administering this law, we must have a succinct way, like Malord the Sapinda, as your lordship said. These are all principles which have come this way. So, Malord, evolution always happens. So, social reform, consistent with evolution and progress, is not, Malord, an anathema to a religion. But if that religion is substantially being prejudiced, then your lordships have to consider whether it is a direct invasion of 25.1 and also, Malord, 26. Because, Malord, 25.1, when it says nothing in this article, Malord, there are two interpretations possible. One is the extremely learned interpretation which Dr. Dhaban placed, namely, it removes the right and it also removes the limitation. Well, I would say there's nothing in this article is really for the purpose of enabling the state. This is only for the purpose of enabling the state to legislate and to legislate in respect of very restricted matters. So without these restricted matters, and without it being subject to public order, morality, and health, the essence of religious freedom under 25.1 and 26 is completely preserved.
Mr. Subramaniam, so I would understand you to mean 25(2)(b) is a narrow window of legislative competence vis-a-vis, in accordance with law, qualifying clauses C and D of 26 1B,
Yeah.
26(1)(c) and D, management property. That is, any general law can
Yes.
interfere with the right of the denomination to hold and manage the property.
Yes.
But when it is impacting affairs of religion, the legislative competence is to be posited to 26(2)(b), that is social reform or social welfare alone.
Correct, Malord.
So general law cannot make an inroad into it.
No.
This is what you are trying
Exactly.
to make.
So, Malord, sorry.
So from there, my next clarification I seek from you is, what is social reform and social welfare? Will the state be understood to be within its limits if it says that it is enforcing constitutional duties in enforcing a law or in making a law under the ambit of social reform. Because the state has some constitutional duties envisaged under the directive principles of state policy. It has a constitutional duty to enforce fundamental duties of its citizens. So will these qualify social reform legislations?
My lord, let us take a case of, say, superstitions. Or let us take a case of completely practices which are abhorrent to morality, but which have been conducted in a certain place. Well, the legislature can intervene. It can intervene on the grounds of social welfare and reform. So it is not that social welfare and reform, my lord, is very limited. It can be, my lord, actuated by a proper purpose. But however, what I'm submitting is the extent of invasion.
I just wanted a
Sorry.
clarification, because the word is social
Yes.
and directive principles are constitutional visions.
Yes.
So will the constitutional vision of the state be a part of social reform legislation?
My lord, this is again a fairly profound question. My lord, if your lordships look at the preamble, in the preamble there is both the coexistence of justice, political, social, economic. So my lord, I'm not for a moment downplaying the importance of that question. It's a very valid question because my lord, you have to secure to citizens.
Why I am asking
Yes,
this
yes.
question is because we are delving on the question of constitutional morality vis-a-vis public morality.
Yes.
Now, if we're trying to eviscerate the two, differentiate the two, then when it comes to legislative competence of making inroads, should we again make compartments between social reform and constitutional reforms through enforcing visions as envisaged under Part 4 or fundamental duties?
My lord, in one of your lordship's previous interactions, my lord, in these proceedings, your lordship said that constitutional morality could be the conscience of one person, but someone else may have a different standard of morality to judge it. But, my lord, as far as constitutional ideology and assurances are concerned, it is something which is relevant for the state. But, my lord, this freedom, if it has to be preserved as a part of the basic fundamental freedoms which are integral to the basic structure, my lord, this freedom of religion and conscience is inherent. It is a very important freedom. Then I'm afraid, my lord, we have to read the power of legislation very strictly. And it must be able to establish a direct nexus between the need for that reform and the objective sought to be achieved by the legislation to accomplish that reform. Otherwise, my lord, 25(2)(b) will be completely an overarching, shall we say, it will be a silent inroad into religion.
Yes. For example, suppose the Kerala rules, Act and the rules, for example, had said, in the name of social reform, the entry of women between the age of 10 and 50 to the temple is permitted. Is it an invasion? Or it could be said that it is not an essential practice and therefore upheld. What's the extent of invasion then?
My lord, even in that case, your lordships would have to be satisfied and would need to undertake an inquiry to see whether the exclusion as a part of ancient tradition or custom or usage was one which did not fundamentally take away the rights of devotees to go to the temple. That's not the test. That is, in other words, if it is a limited category and it is based upon a rational and it is also a custom and a usage and it belongs, my lord, to a denomination, because, my lord, the word denomination I'm interpreting widely. It is in the context of a faith-based denomination because it's much easier, my lord. Otherwise, we will not be able to prove multiple castes, multiple communities, and it will be completely. So it's better to make it sound and principled. And I submit with respect in such a case, if the usage is present, custom is present, it is entitled to respect, my lord, ipso facto as a part of that tradition. Malad, customs and usages cannot be thrown away. Malad, we will take simplest customs before you enter.
The rule has to be struck down.
Malad, in that case, it would have to be struck
Yes.
down.
So it need not be on the basis of essential religious practice. Merely because of an invasion into a religious practice, it can be struck down.
It can be.
As it is only a cloak
It
or
can
a
be.
color of social reform.
It can, Mulad, it can be. That's why I'm saying,
Yes.
please treat even, there is an element of Mulad, automatic strict scrutiny when you come to the words in clause B. Because Mulad, you are passing a law to invade religious freedoms. Therefore, Mulad, it must be a law which passes tests in all senses, Mulad. It is for the true purpose for which it was intended.
Conversely, if such a ban or whatever it is questioned in a court of law, can it be that ban be struck down on the basis that it is not an essential religious practice?
It can be.
Conversely,
It can happen. That is why, Mulad, please don't throw away the idea. My submission is, please do not jettison this concept of essential religious practice. Please don't, because I'll tell you how useful it is. Mulad, when Justice Gajendra Gadkar in the Dargah Committee said, and Mulad, he was also a very progressive judge, but he was also, Mulad, one who was profoundly learned. He said, the crucial words are, don't allow anything, Mulad, he used the word superstitious. If suppose he had not used the word superstitious and said, don't allow anything extraneous to come into religious faith, Mulad, it's completely unobjectionable. Because when, Mulad, a religious right is asserted, the court will take care to see that it is, Mulad, a valuable religious right which is asserted. Mulad, it has to be discovered. And therefore, Justice Gajendra Gadkar said, when we have anything which is extraneous, Mulad, he was so careful. The later words have to be read. He said, if suppose such a claim is made under Article 26B, then that claim will have to be very carefully scrutinized. I think, Mulad, there's no objection which one can take to that sentence.
Now, how do you define the social welfare or social reform? The question is only with respect to this. 25(1)(a) says it's subject to public order, morality, health, and subject to the other parts of this part. If you juxtapose that to religious denomination, which is again, as well said, it is nothing but a collection of belief. You can, what is applicable to a person or group of person will applicable to the religious denomination also. That's the reason why you also said 25(2)(b) will applicable. So as my brother Bakshi also said, can the state be, can it be said that state can restrict the right subject to other provision of Part 3 alone? Because 25(1) itself says subject to two factors. One is public law, morality, and I think other is subject to the other part. To give effect to the mandate of other provision of Part 3, starting from equality, Article 15 and 91G, can it be said that the power of the state to pass a law is confined to ensure the due compliance of Part 3, other provision of Part 3 alone, because anything else is not restricted under 25(1)(a). Is it a proper way to look at it?
No, I've understood, Milord. Let me straighten. I'm very grateful. Milord, my submission, Milord, I like to be clear because my purpose is to assist you and to help to draw, Milord, not necessarily bright boundaries, but there has to be clarity and consistency. Milord, my view is that Part 3 is not available as a ground for legislation under 25(2)(b. And nor is it available under 25(2)(a). 25(2)(a) and 25(2)(b) occupy territories which may have some, shall we say, idealistic overlap, but the legislation cannot be done with reference to Part 3 because, my lord, what happens in 25(2) is it lifts both. It enables a legislation, but it also My lord, removes the subjection to part 3.
All right. Now, a religious practice directly comes in the way of the other provision of part 3. What will the state do?
My lord, it depends, my lord, upon a case to case. Let me give your lordships a small example.
Under which provision, under which the provision of law, under which article the state can assume power there?
My lord, that will, if I may say so, my lord, if your lordships don't use the word part 3, but if it is social reform proprio vigore,
Yeah, that is obviously it's, prohibited under 25(1)(a).
yes,
It's subject to that only.
yes, yes,
So it is so apparent, state is of the view
yes,
that either it's public order morality or other provision of part 3
yes.
is violated by through a religious practice. It is so apparent. Can it pass a law or not? If it passes a law, under which provision it will come?
My lord, if suppose, let us say, I'll give your lordships, my lord, a clear answer. My lord, for the purpose of a law under 25(2), my lord, if a law has to be passed with reference to the opening part of 25, or shall we say opening part of 26, you already have 3 grounds which are available. That is, my lord, the grounds which are public order, morality, and health. There are 3 available grounds. Now, what does actually 25(2) do? In fact, it does is, your lordships are looking at subject to the provisions, other provisions of this part. Subject to the other provisions of this part, my lord, is in the context of protection and equal rights of religion which are granted to others. It is in that context I'm interpreting it. But I'm saying anything, my lord, which comes within, shall I say, the reasonable ken of social reform, my lord, that is social welfare and reform, will pass under 25(2)(b). But it must be established that it is, my lord, an authentic social welfare reform. So I'm saying, so my lord, it might be that a violation of a fundamental right, now I'm going further, violation of a fundamental right may acquire, shall we say, the appellations and attributions of a social evil which needs to be addressed under 25(2)(b), then, my lord, the legislature necessarily has that power. So I'm therefore reading that the power is there as long as you can demonstrate by means of objective assistance that this is a social evil, this is a social welfare, this progressively takes it forward. My lord, this would be a very harmonious way of reading it, because otherwise 26, as I said, my lord, will get unnecessarily impaired.
Because it's better for us to
Yes,
define it.
I
Otherwise,
agree.
why we are telling you is this, we don't want to give the impression of giving too much of power to the state also.
I understand. my
If
lord.
we restrain, if we draw the contours somewhere,
Yes,
like you are also example, you quoted what I have said
Yes.
earlier, Section 6 of the Intersection Act.
yes,
If you want to bring it under 25(2)(b),
yes,
it is not only you can't bring it as a public welfare and then say the public reform, but necessarily you have to go back. What is the extent? To that you have to go under Article 14, 15 and other provisions also.
my lord.
Because it is subject to that. Because if they come under this, because absolutely it shuts the door for a religious practitioner, because it subject to that only. Your right is subject to that under the Constitution.
My lord, may I just explain the point like Section 6? It's an excellent point and it's a very good example. My lord, Section 6 belongs to the realm of personal law, as your lordships know. Your lordships know the progression in relation to the right of a widow to hold property, first, my lord, under the 1937 Act, and even under the 56 Act, my lord, it was the Justice Syed Fazal Ali's judgment in Tulasamma, that is, when he said 14(2) is absolute. It is only then, my lord, the law became firm that they had absolute estate and they could alienate properties. Till that time, my lord, it was not possible. Now, this, my lord, is actually an amendment. But as your lordships rightly are aware, that there can be even discriminations within the realm of personal law. The removal of that discrimination can still be a social welfare reform, which is directly falls within the province of 25(2)(b). So, my lord, for the purpose of removal of discrimination, you don't necessarily have to go back and hearken to 14, although it is a salutary. But, my lord, you can remove it as a part of social welfare.
For example,
Yes.
for religious denomination believes that a lady who becomes a widow has to commit sati, and therefore sati must be abolished in the context of 25(2)(b, it cannot be considered to be an invasion of a religious practice.
Certainly not.
We are giving these extreme examples. So social reform will prevail there.
Yes, certainly. And my lord, it's not only the making of a law, as your lordship said, it is also, my lord, the conscience with which that law is implemented over a period of time. My lord, even though we have had laws which were social reform laws, as a matter of accurate, my lord, if one had to do proper sociological studies, it has taken a lot of time for many of them to have been translated as complete realities. So there is a gap, my lord, even between effectuation of a law and the time by which, my lord, society adequately responds to the law and imbibes the law as a value. So therefore, my lord, I would honestly say that under 25(2)(b, social welfare and reform, my lord, are capable of a wide expression, but they must be, my lord, honestly falling as social welfare and reform, and they must not also, my lord, completely eviscerate the right of the denomination under 26. That is the point.
A harmony, that's what in Venkatramana Devaru,
Yes.
ultimately it is stated. The proportionality.
In fact,
What is invading what?
in fact, that
Probably the issue I think stands quite well debated. Part 3 is an embargo on 25(1). The individual devotee's right that when you exercise that right on 25(1), you have to respect the Part 3 also. So far as social welfare or social reforms are concerned, it's a very wide term. State is not a stranger. State is not an alien. State represents the will of the people. And if the people want certain social evils to be reformed, probably that power can be exercised. But it's very difficult for us to lay down any future guidance. It will always depend upon a case to case whether the reform falls within the ambit of 25(2)(b or it amounts to exceeding the power under the name of reform, introducing something which amounts to infringement of a religious practice protected under 25(1).
And my lord, to be fair to the learned Solicitor General, who do not have the benefit of so many other submissions, he seems to take that position. His position is that there is a separation between religion and the state. Second, there should be minimal state control or incursion when it comes to 26(b). Third, he, my lord, went up to a point, but I have elaborated it, that every denomination means, my lord, it belongs to every faith. Section thereof will deal with all these subsects. And lastly, my lord, on this question of 25(2)(b, that power, my lord, must be available with the state, even though denominational freedom is being given and the right to religious practice is being totally accepted and preserved. So, my lord, with this, I'll be very, very quick and brief. My lord, if I may just give me my lord, I have given an additional submission for your lordship's consideration, but on this concept of religion, I wanted to show a few passages, my lord, from the original submission. My lord, this is volume 1.2 in the soft copy.
596.
My lord, it starts at 595. And if I may take your lordship straight away to, my lord, 3 paragraphs, 19, 20, and 21. That's at page 602.
Volume?
19, 20, my lord, volume 1.2, my lord, page 602.
Para 19.
Para 19, my lord. It is submitted that the etymology of the word religion is from the Latin word religare, And the concept itself is difficult to define in such a way as to comprehend. So sorry. Page 602, my lord. Well, the running and PDF are the same. So fortunately, 602, para 19. Incidentally, my lord, as a digression, the reason why Justice Mukherjee one sentence that it's not possible to give a rigid description for the word religion is, my lord, largely because he followed also, my lord, the section of philosophy, Bertrand Russell's theory of specifications. So unless you have a completely exhaustive enumeration, you don't say you rigidly define a particular term. So, my lord, that is why those words come in the beginning of the passage. Then the Latin word religare and the concept, Sir Edward Bernard Taylor defines it simply and briefly as being a belief in spiritual beings. According to Goblet Alveolar, religion is a certain method by which man realizes his relation to the superhuman and mysterious powers upon whom he regards himself as dependent. A more comprehensive definition is that given by Jean Rivet. Religion is essentially a principle of life, the feeling of a living relation between the human individual and the powers or power of which the universe is the manifestation. What characterizes each religion is its way of looking upon this relation and its method of applying it. Perhaps one of the better indicative definitions is that of Fraser. By religion, I understand a propitiation or conciliation of powers superior to man, which are believed to direct and control the course of nature and of human life. In more contemporary terms, Professor Thomas Tweed defines religion as religions are confluences of organic, cultural flows that intensify joy and confront suffering by drawing on human and supra-human forces to make homes and cross boundaries. Well, this, I submit, gives you at least a wide array of thought of what actually